a great presentation and one of our most highly attended that we do. So thanks again, everybody. Thank you to our sponsors. Many of you are from our sponsor companies. Our sponsors are listed on the front page of your presentation handout. And without our sponsors, we wouldn't be able to do these presentations each year. This is the first of 4 presentations. We'll have one approximately every 2 weeks. We've got another series of what I think are really good presentations for you this year. So we hope you'll be back for more. Hope you enjoyed today and join us afterwards for hors d'oeuvres and for drinks. So you all in Zoom land can't do that, but thank you for joining us as well. All right, Jim.
Okay, I think we're ready to start.
All right, let me get that up.
Yeah, you tell me we're ready to kick off.
Do you mind just testing the pointer?
Absolutely.
Oh, now. Awesome.
Okay. Good afternoon. I'm Jim Kelly. Pat O'Donnell and I are here. As Tony said, we're going to kick off the first seminar. So we're almost like Broadway. As Tony came to Pat and I and said, hey guys, we want you guys to do the ethics compliance training, kick off the fall seminar series. And Tony said, it's going to be just like Broadway. Well, he's right. You got drinks in the crowd. We're not drinking, but people in the crowd. I want to make it clear though, when Tony asked Pat and I, well, we're going to do some singer, song, and dance routine. No, that's the way Broadway opened, but we draw the line on that. So let's go ahead and start. We can. We're going to go over some stuff today. Today, we want you guys to ask questions. I think probably better at the end, but if a major question comes up, please put your hands up, okay? So let me just quickly go over some of the highlights of 2021. So the Department of Justice is excited to tell you they collected $2.2 billion in False Claims Act recoveries in 2020. They said, well, we were a little slow because of COVID, but we still collected a lot of money. In the first quarter of 2021, last year, they collected $3.23 billion in the first quarter alone. But that's attributable mostly to the opioid settlement. So it was an $8 billion worldwide settlement. U.S. government grabbed about $2 billion of that. The foreign corrupt practices, record-setting recoveries last year of $2.78 billion. What are some things we're going to cover today? Well, when we were all talking about doing the seminar, we postponed it from September to this October 21st. On October 6th and 8th, DOJ launched a new cybersecurity initiative. So we're going to talk about that today. The new cybersecurity reporting requirements. We have now the COVID vaccine mandates are out. We're going to talk about that today. The DOJ strike force is still out there. They still believe there's price fixing and bid collusion. We're going to, Pat and I will talk about conflicts of interest, personal and organizational, mandatory disclosure, the 889 rules, and ethics compliance programs. So the first thing is, why are we here today? Well, because we're defense contractors doing business with the U.S. government, we have to have contractor compliance programs. Doing business with the federal government, we all know, sitting here, is different than doing commercial. The federal government has its own rules, procedures that we have to follow, reporting requirements. They're designed to prevent and punish fraud, as that's their saying. Sometimes it's overreaching, we know that, but those are the rules we have to follow if we want to play the federal contract game. Each company must conduct its business with the government with the highest ethical standards. Procedures have to be in place to safeguard. Pat and I are going to talk about that today, to guard against improper actions. And you've got to comply with the federal regulations and rules. Contracts with the U.S. government. Types of contracts and requirements: fixed price, cost reimbursement, time and term. We all know those. Under a funded contract, we've got to track your job charges against the funding under the government contract ordering or work level. Now, I put in this next line here, the contractor must notify the government or prime contractor if additional funding is needed and secured before you accept new work. One would say to me, that's common sense. I had an experience last year with major overruns. The government commingled funding, muddled it up. My clients got notices there's no money left in the contract. We're still doing work. We're able to straighten it all out. But be mindful on certain contracts, foreign military sales and others, money gets muddled up. Luckily, in my situation, the government did more muddling it up than my client, and we got it straightened out. But be mindful, it does come up. And as I talk to people, they say, yeah, you have to be very careful. If you go and exceed with that beyond the funding, you can become a volunteer. And as we all know, the graveyard is full of volunteers on government contracts.
You have, a lot of contracts have a provision where you have to give notice when you approach within a certain percentage of a ceiling. If you don't give that, then you
You're a
risk.
charity.
You're performing charitable work.
Right. And then no, is you bidding as a prime contractor or a subcontractor. So why do we have a compliance program? Well, under the FAR 52-203-13, you've got $5.5 million in a contract value, prime or sub, and a performance of more than 120 days, you have to have a compliance program. And we know that. We've talked about that over the years. If you don't have a contract in excess of 120 days or 5.5 million, you still got to have a compliance program. And most major defense contractors and private contractors, because of their requirements, require you as a sub to have a compliance program. No one wants to get tarred with a guy who does not have a compliance program. We're also going to talk about why do you want a program? If something goes south on you, you want the program. You want to have a program in place, and Pat and I will talk about that. So what are the key components we've gone over before? The ethics compliance program, written code of conduct, how you're going to deal with disclosures, cybersecurity programs now required, the procedures, federal statutes, you got to review the statutes each year. Do you do reviews of your billings and payments and allocations, standards of conduct, enforcement and disciplinary actions, and you have to have whistleblower protections. Periodic review of your company business practices. Do you have the hotline postings up? Do you have referrals in your code of conduct? You need to make sure that's there. A big issue that's been out there since 2009, we're going to talk about, is timely disclosures to the government of improper overpayments, improper conduct, billing errors. And be mindful, I don't know if it's just covert. In the last 2 years, I've witnessed a lot of billing errors. I've witnessed my clients being paid, excited about getting paid, but then realizing they were getting paid for work they didn't bill or do. So now you got to go back and say, hey, I'd rather have you pay me what I did, but you'll be mindful. As we've always said, if you have a question, raise the question. Remaining silent is not a good plan.
And just so you know, the requirement goes on for a long time, but the False Claims Act has up to a 10-year statute of limitations. Not for everything, but that's an awful long time to not be sleeping well at night.
And be mindful that after with your closure contract, if you discover problems, you have 4 years for the final settlement of the claim or the final billing payment, where they can come after you, that you have to raise your hand and say, I've discovered you guys paid me 3 times. One of the big issues out there, we'll talk about a little bit more, that I'm mindful of, that I've had DOJ matters over the years, is where the company did not properly allocate the funds when they came in. And it resulted in mistakes later in the double billing. And the government says under the 2009 Act, that's your fault, not our fault. So how do we get there to what we want to do? What Pat and I have always said, and I think the takeaways, have a plan and have a plan, a code of conduct that everyone can understand. As I think we've joked about for years, the 120-page plan is not a good idea. Because when something goes south, they go, we'd like to see what you did on page 67. Well, I didn't even know I had a 67 in my plan. We want to keep it simple, straightforward. Doing business with the government. What are the guidelines and rules we have to follow? Identify your compliance officer. This is a big mistake people make. Who is the compliance officer? So they understand. Who can they go to? Can they call him? Can they write to him anonymously? How can they get in touch? Can the compliance officer force corrections and changes in the company? And then you make sure there's a written code of conduct. I'm a firm believer when I do programs for companies, I think Pat does the same thing. Have a signature page. You understand what your requirements are. Your code of conduct, ethics, compliance, doing business with the government, mandatory disclosure, conflicts. There's a lot of companies that get into problems that their employees are doing business on a side business, competing against the prime and against the government. Be mindful of that. We talked about the code of conduct. In today's era, we're politically correct in 2021, entering 2022, but you have to maintain a code of conduct. What health and safety, environmental laws, equal opportunity, avoid conflicts of interest, gifts and entertainment. Watch that. Most companies have gone to no more taking lunches, playing golf, paying for golf with the government. Have to make sure there's no retaliation policy against people that raise an issue. What are the employee duties and obligations? So what we want to do before we get to false claims today, Pat and I talked about, is we've had obviously cybersecurity has been in the newspaper. almost the United States government, as well as companies, continually have breaches of their security matter. But if we as contractors, what are we responsible for? Well, FAR clause 252, 204, 7, and 12 outlines what requirements we have. Everyone probably knows that in 2021, they changed their incident reporting requirements. Now you have to report within 24 hours of discovery of the incident, not 72, and you have to have a report within 72 hours. You want to be mindful of that. And the reason I bring that up is the next header is October 6th and finalized on October 8th, DOJ launched a new DOJ cybersecurity fraud initiative under the Civil Division Commercial Branch. It's going to target U.S. government contractors who don't follow the U.S. government cybersecurity requirements. So what does that mean for us today? Well, what the government's going to do to get our attention, they're going to use the False Claims Act. You recall Pat and I over the years talked about the Rocketdyne Teledyne case. It's out there where a company on a bid certified they met the requirements, and a relator said they don't meet the requirements at all. So there have been a lot of cases where U.S. government DOJ has gone after people based on relator actions. I saw one just I looked up last week. There was a claim for $750,000. The relator took $170,000 for just turning the company in and saying, well, they don't comply. So what does the government say that what they intend to do? They're going to go after companies if you provide efficient cybersecurity products and services. I don't think most of the people here, we don't engage that business. So we're lucky. But the two other things we have to be mindful of is we misrepresent cybersecurity compliance at the time of bid. That's a certification. And if you read into the fine print, so to speak, pulling back the onion, to look at these things, they're going to consider those false statements and false claim actions. If you certify.
There's been two federal court opinions upholding the use of the False Claims Act for cybersecurity misrepresentation or miscertification. So it's not new, it's not untested, it's been tested in court and found to be a valid exercise of the False Claims Act.
The Civil Division will get into later on the whole price fixing on with initiatives. They have 13 groups. They got excited, and the people that work part of that initiative joined in this cybersecurity initiative. They see travel is going to return, great opportunities to go over, but these are real issues. So be mindful. That's exactly right. The federal courts have said we see it as false claims matter and time of reporting of any breach within 24 hours. You know, then you've got the issues of our control and handling of CDI, cybersecurity materials, receipt and method and storage. How do you do it? Basic security controls. One of the things that I've had come up as you work around the world is we've gone back to the DOD and DOJ and saying, hey, we understand the controls, but you have us interfacing with your designated parties. You know, we can only go so far with security. So be mindful of that if you have an issue with your with the government and how you supply and how you guard the flow down controls at the contractor and subcontractor level. But I've raised the issue with several DOD commands that, hey, you have us doing things, we're trying to safeguard, but I don't know who these people are, and I don't know the level of measure of security they have. And actually, we've done mods and written cover letters. Mod probably you've done the same thing, Pat. We've done it with Transportation Command and a few others to safeguard and say, hey, I can only look beyond the wall I can see.
And we have the Virginia Ship Repair Association has given seminars on the CMMC initiative, which was to be a kind of a unification of the cybersecurity requirements on contractors. That has been put, I don't know if it's been put on formally on hold, but the Biden administration has stepped back and said, no, we're going to re-review some of that. There was a lot of pushback from industry, a lot of uncertainty. So I think that's on hold right now, but you still have the DFAR requirement that Jim was noting.
So moving on, the other thing that hit the stands, it hit the press from September to now is the latest COVID vaccine mandates. Now, we all thought we were safe. We understood what the rules were. I could get a booster and I couldn't get a booster, but now Executive Order 14042 came out September 24th, federal safe guidance. And then you got a FAR and DFAR clause in its draft form. So now you're dealing with rules for covered contractors, covered employees, and covered workspaces. And As we all know, the general headline mandate is that all contractor covered employees must be fully vaccinated by December 8th, 2021. And what does that mean? And what are the exemptions? Well, the first thing is you've got to be vaccinated in order to meet the requirements of the 2-week spread. Your employees have got to get vaccinated by the third week of November to meet the 2-week spread. You've got a fast approaching deadline. As you may or may not know, DOD is not giving guidance. They have promised guidance for now. It'll be 3 weeks Friday. They're working on it. They haven't. I had a client at a 4-star command the other day, and they basically said, guys, we apologize. We know you got Jim Kelly's questions. He's peppering us. We have no guidance. We're stepping back for 2 weeks. We can't get guidance. We don't know what to tell you.
I will say that it says October 13th. It actually would come out until like the 16th. But GSA, if you go online, you find GSA has issued some guidance
Yes.
On this issue.
So I think that, one of the issues that's come up around here, and Pat and I were talking about this. What's the effective dates? How does it apply? What does it apply to federal property? So one of the issues that's come up is the questions being raised are, okay, government property, what does it require? Are you saying to get access to the government's base to do production, what I call production work, the vaccine required? What about a meeting at a command or a base? What's required there? That's what people asking for. What about the exemption requirements? Who pays for those? Under the executive order, an employee gets time off and gets paid if he has to go during employment to get his vaccine. And if he gets sick, he gets it paid for a day or two. But if you want an exemption and you qualify, there's questions right now, who qualifies and who not, both under medical and religious. But then the question is, if you qualify, you have to wear masks, you've got a social distance, and you've got to provide a negative COVID test each week. The consensus is in Washington last week that the insurance companies that do cover the testing will stop the testing within 30 days. In Washington, if you need a rapid test, it's $175. And I don't see the insurance companies doing that. So those are a lot of questions that are out there. Be mindful of the requirements. One thing that I would caution everyone here is if you're bidding a job right now, I would put cover language. I would recommend strongly cover language in your bid submission. If you're reserving your right to make adjustments in both your pricing and schedule. Because right now, we don't know what the final rules are. We don't know what the exceptions are. We don't have the final DOD guidance. And so what I'm saying is we're reserving our rights for schedule adjustments, RDD, some people call it, and the price adjustments. I'm also reserving the rights because I don't know what other actions the US government may take or third party that impact my performance.
Yeah, the only caveat to that is the GSA guidance seems to be, yeah, you put whatever you want in there. That's all nice. The answer is no, even though we're supposed to do a mod, bilateral mod. The way I read this, they're not gonna cut much slack on it.
Well, it's interesting on the GSA. So I've had clients, GSA tell them, we understand what you're saying, put the restrictions in.
Well, their guidance doesn't seem to invite it.
No, you're right. But I mean, the problem you're going to have is you do have a change that particularly if, here's an interesting one. If you bid, the solicitation came out, I just had an inquiry this morning, came out with the company's bid and the award came out with the rule, but no bilateral mod yet.
Mm.
So I bid without the rules. Your solicitation came out, I bid and you awarded me. Now the rules are out. Oh, I ain't gonna apply to me.
And the guidance also says if you have an IDIQ contract or any types of, or any subject to an extension, none of those will be awarded until you have the mod, you include this language. So you're not going to get any contract extensions. You're not going to get any new orders until the COVID language is in the contract.
The question is, what is the final language of look like? That's what no one knows. And I agree with Pat. I mean, all the reason I put it in is you want to reserve your rights. Later it becomes a fight, but if you haven't reserved your rights, then they're going to say you signed the bilateral law.
Oh, I absolutely have to try. You have to try to get it in.
Yeah, interesting enough, I've had one group tell my clients they're not going to issue the bilateral bonds yet because they can't get guidance. So I was happy to report that they exercised the option to the entire year contract earlier. and they want to have some minor modifications, but it's gonna be, I agree with Pat, it's gonna become a big issue. So the latest is this morning, I was talking to people as we started here, there are rumor mills out of Washington that if this thing doesn't get straightened out in the next 2 weeks, it's gonna be, I can get a 5-year-old to tell the calendar, it's impossible to meet the date. So is it gonna roll? And there's starting to be rumor mills, I count them 50-50, the thing is gonna roll. The 7 or 8 date is gonna roll because the government can't agree on what to do. And the problems you've got out there is what do you do at a controlled site? Are there exemptions? Can you deny access? And then what are you gonna do to people that qualify under the Americans Disability Act with a legitimate medical? Can they work? Do they not go to the work site, but can they work as a covered contractor at his work site if production work's not being done?
And it gets complicated because if that person is working with someone who's then going to go visit the
This
site,
place becomes complicated.
yeah, then you've got another issue.
The Supreme Court Tuesday night turned down, not that I'm living in the state of Maine, but I get all the Maine publications 5 and 6 times a day from Portland, the newspaper. They turned down a petition for 8 health workers in Maine who are objecting to the health mandate. But that's a trickier one because it's a health safety standard issue. It's different than the normal work site. And the Supreme Court refused the petition. They said, no, it's a valid health and safety rule in Maine that all health safety workers at hospital have to be vaccinated.
I got a question.
Yes.
Sir. From what I read, correct me if I'm wrong, did it say something about October 15th for that FAR DFAR clause, and then no later than, I think it was mid-November? So it's going to be a bilateral period between the October and November date, and they come November 14th or 15th, it was going to be in all contracts.
There are 5 bullets there, and Patty's saying, where it gets complicated, it's solicitations were issued prior to what awarded out. The solicitations on the 15th of October that get awarded by November, those afterwards. But you've also, as Pat properly pointed out, you've got IDIQ contracts, and you've got multiple contracts that I'm involved in that are multi-year, that because they allow individual yearly pricing, if you have an award every year, you have a modification that accepts, year 2 pricing. I had some of the transportation ones were all awarded prior to. But so you've got 5 points of how these dates apply, and that's one of the things that is being asked. But I had a command tell my client the other day that we're rolling back on things. We can't get guidance, so we're going to hold off for 2 weeks. We're not issuing any mods to implement control rules.
So Jim, what happens if a contractor has 10 contracts going on at the same time? The mandate comes into effect, we lose 25% of our workforce, and we can't perform, and there's LDs on 5 of those 10 contracts.
That's gonna be that's one of the issues that's out there. You're right, you can't perform because I've lost my workforce. You've imposed change. My contracts were existing in place before your work rules. I did the job. We're putting out on notices to people with existing contracts when they're coming with notices. And I was told several people got letters, not mods, letters that they wanted to sort of see and agree from GSA and others. Hey, there's a new rule out. Will you agree to it? No, not without my 2 paragraphs of reserving my rights.
And check to see if your contracts have any kind of force majeure provision that, act of God, act of government that you can hang your hat on to seek an REA or an extension of time or whatever you need. But as Jim was saying, you got to at least try to get some language out there that you're reserving your rights.
So later, if there's a court fight, you want to at least be able to say to the judge or the contractor, hey, Your Honor, I tried everything I could. I wrote letters, I wrote caveats, I changed the letter to protect myself because these are existing contracts. Yes.
Any risk in the reservation of rights being viewed as qualifying a bid and ruling you out as a result of?
Well, generally they'll raise that issue in the bid, but I'm going to put it in there initially because I don't know what's going to happen.
Right, it is potential risk. But then if you don't want to do it, you got to accept the risk that you'll be awarded the contract and you have had no reservation whatsoever. So it's a kind of a damn if you do, damn.
Yeah, one of the things that Chris, great question, when I saw look is someone asked me the same thing. What's the calendar look like? If I'm bidding the job right now and its bids are due, I'll just say the 2nd week of November. They're telling me the award is scheduled for the 3rd week of January. I'm sort of counting the calendar And I say, oh, I'm gonna amend myself. If guidance comes out or whatever, or they release things, then I can change my position. But right now, as Pat said, my concern is if it's not in there and you get a fast track award, you're gonna say, well, you didn't say anything. Tony raised holy hell, but you didn't say anything. So, you know, it's a lot of untried territory out there. But I think that you're better off to protect yourself. We also did them on some people were doing bids to prime contractors that, you know, we're doing the best we can, but it may be interim pricing because we don't know what's going to happen between now, the DOD final rules. We don't know what's going to happen with what rules you come out with as the prime, and we don't know what third parties may or may not do. So many contracts are dependent upon third party interaction or lead action. But I mean, it's open a can of worms, as we all know.
Well, it's going to be a mess for a while.
Yeah.
Because, you know, we've already encountered a situation where the installation has contracted out to a third party based security in and out. Well, and that third party company they don't know what to do either. So they're just saying nobody's getting in without a vaccination card. Nobody.
And then you've got the rules. I mean, we have enough problems at Long Beach, you know, LA. You see Gene Soroka on the TV all the time talking about it. But how do you get to solve the problem? And then you've got the situation with how do you get on the bases? You're moving the DOD cargo, picking up or delivering it. How do you get on? And all that's some bases view. Hey, I'm gonna let Tony drive on. He's got a mask. He's the driver. I just don't ask him not to go to the cafeteria. Just drop the container off, pick up the cargo. But other places saying I may have additional screening. So, but that's where we stand today. Obviously, we'll try to monitor this. But I mean, everyone's so it's 50-50. Everyone's frustrated. I know the big DOD contractors have been in at DOD saying you've got to give us guidance. Okay. Pat, I'm going to move over to you for the False Claims Act discussion.
All right, I doubt anybody in here is not familiar with the False Claims Act. It is the equivalent of the Swiss Army knife for government lawyers because it can be used in almost any situation in order to recover monies or punish behavior by the contracting authority. Now, it's been around forever. I mean, the two statutes, the civil statute and the criminal statute, but the statute dates from the Civil War. Abraham Lincoln pushed it through during the Civil War to combat war profiteering by Union Army suppliers. Later, coverage was added. Shortly thereafter, coverage was added. Key tam actions. Key tam action just means that it essentially deputizes private citizens to bring, in the name of the United States, actions alleging fraud, any improper billing, anything of that nature, and present their information and facts to the government, and the government can or cannot, deciding what it wants to do, take over the case and proceed with it. If the government takes over and proceeds with the case, there is a bounty that is given to the private individual if the case is successful. If the government doesn't want to pursue it, the private person can go forward with it on their own dime. And if they succeed, they get a bigger share with a bounty. Most of the money will still go to the government, but they get a larger section or a larger reward for bringing the action. When it was first enacted, it was clear that the contractor had to knowingly, with actual knowledge of the falsity of the claim, that's what the conduct required. We go to the next slide. Now, there were all sorts of articles. The Washington Post, New York Times were constantly doing articles during the Reagan administration, which was injected huge amounts of money building up the military and coming up with examples of a $500 hammer, $5,000 toilet seat, cigar holders, all sorts of, relatively small but egregious examples of overbilling. And so there was a big push in 1986 with the bolstering the False Claims Act. And the biggest, from my perspective, and I think probably Jim's perspective, anybody who's a lawyer in these cases, the biggest change was the adoption of the deliberate ignorance, reckless disregard, or willful blindness standard. Prior to that time, you had to prove the contractor set out to defraud the government, intentionally defraud the government. Now, and the courts have all upheld this standard, all the government has to prove is that you knew or should have known, given that you're a defense contractor and you are presumed to be familiar with the FAR and the different requirements in the FAR and the record keeping and all those things. If you should have known, based on your experience, training, and everything else, that what you were doing was improper, that would be sufficient to impose both civil false claims and criminal false claims liability on you or the company. And so that describes it here in a little bit more detail, but that's a difficult standard to defend against. You know, companies are all out there. They have compliance plans now. They have training, all these things. So it's very difficult for someone in the industry to say, I had no idea that that was improper, no idea that that was not allowed. In some of the more benign contract, example, contractor does not perform any review of the claim before submission or ignores the facts and just bills. This could be subcontractors. So you have an obligation. You have an obligation to guarantee your subs invoices, but you can't just pass them along either. Just passing them along would be the very definition of deliberate ignorance or reckless disregard. 2009, they keep bolstering the False Claims Act, broadening the definition to include overpayments. So if you get money that you're not supposed to have gotten, you're supposed to know that, and you're supposed to return it. Strengthen for failure to pay an obligation to the government. That can be an overpayment as well. Next. And also broaden the definition of a claim. It's any request or demand, whether under a contract or otherwise, involving property or approval of a contract or request. Claim is not limited to requests for money or its invoices, or for requests for equitable adjustment. And we'll touch on this, but this is another area where we lawyers have seen a great pushback on contractors who submit claims, REAs, and Justice Department claims it's not doing it, but we have seen it where you're met, when you file that, you're met with a claim by the government lawyer that you have exaggerated the claim, inflated the claim, it's not particularly well based in fact, and they say, we're considering making a False Claims Act counterclaim to your request for equitable adjustment or your claim for contract, other claim for contract adjustment.
With that in mind, I've seen situations where, again, you warn people when you see it. Hey, if this claim is very complex, could your client certify the claim and certify the cost and pricing data? So if that's not a warning, check it again. But I've seen that literally happen. Could you do that for us? Or does it help your reading of the claim?
Yes.
But you want to be careful because, as Pat said, if you certify all that later and then say there was no basis for the cost.
And I've seen it where, you know, a contractor has selected an expert, a claims expert that has a fairly spotty track record or doesn't really know the area very well. And the government has said, look, you picked what we believe to be a charlatan expert on your claim, and you're going to be tagged with him. And we might bring a false claims action against you just because we think that expert's analysis is so crazy off the mark here. So you got to be, you really have to go over your request for mods very carefully, make sure they're maybe not bulletproof, but close.
Yeah, you can have an argument. You and I can have a disagreement on the interpretation of a clause or requirement. That's not a false claim act. But what you have to be careful is if you start exaggerating the story or you put in costs that aren't incurred. And the big problem is, you know, I mixed up the cost. I've been at it for long years. Pat had, back in the day, you could say, well, okay, nowadays, wait a minute, if 20% of this new claim isn't even supported, you have a problem.
Yeah, and in the days where the client would say, look, I know we're coming in high, but we're willing to, during negotiations, back that down. Those days are over with. You cannot certify a claim, you cannot submit a claim, you know, to be exaggerated, inflated with the idea you're going to come down later. Okay, and the list just grows all the time in terms of what can be a false claim. In fact, falsely certifying you're meeting all the COVID restrictions, that now could be a False Claims Act violation. But I mean, this list is hardly exhaustive.
It just grows and grows. I mean, there's always.
Like I said, it is the Swiss Army knife. There's nothing that you can do that involves fraud or arguably involves fraud with the government that could not be touched by the False Claims Act. Some of the hot areas that at least in my practice recently, you know, misrepresenting status as a DVE, 8A, veteran, any of those, that's a very hot area of prosecution and enforcement. And, you know, that gets into some very complex things we may touch upon later involving who controls the company. The disadvantaged person has to control the company, and there are all sorts of affiliation rules. And if you fail those rules, and you should, or you knew or should have known you weren't complying with those rules, you're going to land in the False Claims Act area. You know, all these express or implied certifications, your workforce, U.S. Supreme Court case found that if the contract requires a certain level of proficiency, training, licensing of employees, and you don't provide those kind of employees, that is a False Claims Act violation. We touched on some of this. You're going to have to, we're back into COVID. So, you know, COVID, like anything else, if you're required to make a certification, or you're required to comply with a contract provision, and you don't, and you knowingly don't, or you should, or even if you don't knowingly, but you should have known you were not complying, and you're submitting invoices, those can be potential False Claims Act, both civil and criminal. Again, the key TAM lawsuits have been a huge area of proliferation because now every single employee, this is already happening and Jim touched on in the cybersecurity world, employees, particularly in the IT department, they get, you know, the company says, we got to certify at the time of bid, we're going to be in compliance with all these recommendations, and your IT guys go, well, I know we're not. And they know that the RFP went out. Well, now you have a potential key TAM plaintiff because they now know that whatever went out and whoever signed that, if it wasn't them, knows that it wasn't true when it went out. The COVID is such a mess right now that I'm not sure how they could bring it, but it's not beyond the possibility.
One thing to do on COVID claims, and since we discussed it last year, just to keep in mind, it comes up. And several, not in the Marmac area of region of the country, but in other areas, I've had the government come and say, we know we've had a massive disruption to you with the COVID problems, but because of the uncertainty, let's do this. Let's bring your COVID claims under COVID, but let's bring your work disruption claims under an REA. If they're willing to do it that way, I like to know. You want to make sure, Pat said, you make sure the claim is solid. But you know, that way, because some people say, I'm not sure if you can bring those claims under COVID.
And it may be that they're helping you because they may not have COVID related funding,
That's what
but
I'm
they've
thinking.
got other types, other baskets
I
of
told them to
funding.
go ahead and accept their offer, you know, normally they're beating you down, so if they're willing to help you with the claim, go ahead.
You know, and we've seen also a number of paycheck protection program, False Claims Act investigations. And they actually, the U.S. Attorney's Office has set up a task force everywhere to go after those types of claims where a company applied for, received PPP loans, and the government doesn't think they're entitled to them for any number of reasons.
I'm amazed when you see these, there was one, I'm just fascinated, I did as much reading as I could. This guy claimed he had 230 employees, this is Southern's brother, filed for all the payment, paycheck stuff, got all this money, they were buying cars and everything else. I'm thinking to myself, did anyone?
Yeah, there, in that situation, I think I read about the same one, and I think that the government's actually looking at the bank
Right.
in that case, because
Someone
they
has a
did
lot of
no
information.
due diligence
Yeah.
in making the loan.
They just, who is this guy? You know, he had $12,000 in the county. Allegedly, he has 131 or 231 employees. Yeah.
So that's a big area of focus. Okay, we talked about this already with the key TAM actions. You got to be very careful in this area because retaliating against a key TAM relator, that's the whistleblower, which is, what a lot of clients come to us and say, hey, I know who did this and I want to get rid of them right away. I said, okay, so you want to address one False Claims Act issue by creating a very obvious second one. You can't do that. You cannot retaliate against the employee. They are protected. It is a separate violation of False Claims Act to do so. The contractor may, we talk about no retaliation, no discharge. They're entitled to, they're going to go to court. They're going to be reinstated. They're going to get double the money back. So it's very important. And that's such an easy layup for the government. Somebody came to them, filed the key TAM action, made these allegations. Next thing you know, they're fired. I mean, this is the loser. You're going to lose that case, no matter what the merits of the False Claims Act itself are. So, all right, good.
And then I think, Pat, you've already talked about some of this, the problem with parent claim, which you have to be mindful of. And be truthful, valid, legal, and factual basis.
Yeah, go ahead. Oh, and go back to one thing that's very important. Jim has touched on this. And he's had a number of probably more cases than me, but you have to segregate and identify the costs, okay? When you're preparing a claim. You have to keep all that separate, track it separate. And that's a big thing throughout all of this. If you're doing your REAs, if you're doing any kind of contract adjustment, you got a claim because of a force majeure provision, you've got to segregate those costs from the get-go and track them separately so that you can call them up. They're not commingled. It makes for a much cleaner response or claim.
And to Pat's point also, and Pat and I have talked about this, that, if you have contractor responsible issues that clearly had rework or failures, but one of the things that I've seen in large complex claims is, so the government says or suggests, oh, your plan is so perfect, everything was perfect. So I've adopted, I think Pat and I talked about this with claims we did in Afghanistan and stuff, that we never claimed when we removed stuff, we said, okay, we're going to take 10% off or X% off. You could always second guess me money more. You could have done something differently. You could have done this, that. So you want to be careful with 100% claims. Because unless you're, I tell people, you bring 100% claim when I delivered 10 loads of sand and Pat signed for 10 loads. Now they only want to pay me 9. But beyond that, be real careful with total claims. You want to be careful.
Right. It's also a very prophylactic way of insulating your employees from claims that they are, making false statements, anything like that, because you've already worked in a fudge factor because you're going to be attacked. And you'll always give that person something of a fallback position saying, well, that's why I put 90% or a 10% fudge factor, because I can't sign my name to something with 100% surety that everything that we sold or delivered got there, particularly in a situation like Afghanistan.
Yeah, that's it.
Okay, so the penalties are severe. Monetary fines, in each invoice or each claim, each time you submit any paper in support of the claim, everything that could be a claim can be broken down, and that's a $23,331 per false claim charge. That doesn't even get into the actual trebling of damages. That's just for every piece of paper or whatever that could be considered a claim. The treble damages could be the entire value of a contract. Some courts have said if you procured a government contract based on fraudulent information, misrepresentation, then the entire balance of the contract, everything is a false claim and will treble that. Now, there's been some disagreement in the courts about that. Some courts say, no, you have to reduce that by what the government received that was accepted. Some courts say no. So, and the Supreme Court has not weighed in on that. Suspension, debarment, if you are convicted either or found liable civilly after a court proceeding, you're going to be suspended or debarred unless you're with a company that is considered a national security necessity. So, and so for small companies, and it's unfair, but that's just the nature of the beast, that the small companies, they don't have the ability to argue, well, we're crucial to national security. You will be suspended and debarred. We've already talked about protections for whistleblowers. So it is a very powerful statute. We have the Escobar case, which you talked about earlier. In that case, the contractor was supplying, I think, nurses, and the nurses were supposed to have certain licenses and qualifications. Some did, but some didn't. And the court found that, well, they performed the services. Nobody complained about the nature of the way they performed the services, but it was still false. You were billing for people who were supposed to have certain qualifications. They did not have them. And so that constitutes a violation of the False Claims Act, because it was an implied certification that all the people who are going to put on this contract meet the requirements of the contract. They did not. So there was some, before this case, there was a back and forth about whether there was an implied certification. It's clear. If it's implied within the contract, even not expressed, that can form the basis of a False Claims Act prosecution. And that was a big issue in the Escobar case too. Is it material to the government's obligation to pay? The false information, the false representation. Again, it has to be material, but the court has taken a rather expansive view of what is going to be considered material. It only has to have a natural tendency to influence payment of the claim. So, and the Justice Department has taken an even broader view of materiality in bringing or threatening to bring its case. We've already talked about intent. This is counterintuitive to a lot of people. When you think fraud or falsity, you're thinking intent, criminal intent, deliberate intentional intent. And that's not required under the False Claims Act. A knowing violation is when you knew or should have known. Okay, so what's the benefit of finding out something early on and coming in? Now, there's certain, we're going to talk about it later. There's certain mandatory requirements, mandatory reporting requirements. If you have credible evidence, if the company comes across credible evidence of the violation of a criminal statute or the False Claims Act, there is a mandatory reporting requirement. We'll talk about that. Short of that, there are still benefits for the company to self-report or to self-report in a way that says, we're not sure, but this may have happened. We're still looking at it, but we wanted to be upfront. We wanted to let you know and not hear it from somebody else. And so in doing that, you have to identify who may have been involved, what may have been done, those types of things. But that kind of cooperation, the Department of Justice manual requires the federal government to take into consideration and determine whether or not to prosecute, whether to fine, or how much to fine, whether or not to suspend or debar. So there's benefits, but it's pretty much at the complete discretion of the government.
Yeah, I agree with you, Pat. I mean, you try hard, I think, but they'll decide. But if you don't cooperate, then it gets worse. So it's sort of their view is the cooperation credits are out there. So yeah, you are apologizing to probably your company, but now we expect you to tell us who was involved, and so we root out the bad people. If not, then
and in a small company, that's a big issue because if it's a smaller company, then the decision makers are the owners, and cutting them loose, getting them out of the company is not easy. And so you have to really kind of figure out how you're going to do this if you decide to do it.
Okay, I'm going to jump into the mandatory disclosure that Pat alluded to. We've talked about this before. So the 2009 Fraud Recovery and Enforcement Act came out, and interesting enough, it was the day the act sort of went active. I was doing an ethics compliance presentation at the Ship Repair Association. We're down at the battleship. Unfortunately, that morning, that it broke that the first multi-$100 million claims in the war thing with the food contracts. And that's what everyone wanted to talk about. I remember that day distinctly, people were calling you about that, but everyone wanted to talk about food contracts.
That's Zach Leonard?
No, that's Singapore. That's another thing.
Oh.
These are the food supply contracts in Iraq.
Oh.
The indictments of those, they're always in the hundreds of millions of dollars. There's always a misunderstanding over there. But anyway, in the Fraud Recovery Act of 2009, what suddenly happened is that as Pat alluded to, if there's credible evidence you had a problem with your company, intentional or not, by mistake, you've got to disclose that. The FAR didn't describe or define credible evidence, but if you were aware something has gone wrong, improper conduct, illegal conduct, or even you've been overpaid, and that was the big surprise thing. Up until 2009, the 2009 Act, when you got overpaid with the government, you could take some self-help, work with them. But now under the new act, if you don't disclose overpayments, incorrect payments, it is a false claims action. As Pat and I have talked before, the attorney-client privilege is unclear of the act, but it's always better to have outside counsel because there's always an issue with DOJ. Is the inside counsel, is he counsel or business side? Was he running part of the operation? So you're better off to confess or talk to an outside lawyer.
And federal, in my experience is federal judges, the judges in general, will err on the side of protecting communications between outside counsel to a greater degree than they will between conversations inside the company with in-house counsel. It may not be fair, but that's just the way it shakes out.
The contractor, as we say, you cannot remain silent. So maybe the government will catch the mistake. I'll just wait for the next law. You can't do that. Unfortunately, the way DOJ has viewed it since the 2009 Act, if you don't make mandatory disclosures, they view that as one of the principal grounds for bringing suspension debarment action against you. Also be aware of this continuing reporting when you get into close out of contracts and reviewing, particularly if you've had numerous claims and billing, and depending on how you're getting paid, some of the ship repair work is you're not getting paid 1,000 invoices a week. But I can tell you there are a lot of mistakes made by DFAS and others. So when you are closing out contracts, be mindful that you have 3 years after final payment to review how you were paid and how you allocated that money.
You know, one area on the ship repair that we had recently was, you know, because you're making certifications of percentage completion under some contracts. And you got to be very careful that the government's agreeing with those certifications. If the government inspector and your inspector are in general agreement where you are on that percentage completion, because if they disagree and depart on that issue, and you're submitting invoices based on what you say is percentage completion, you may end up in this problem in terms of False Claims Act, or at least a mandatory disclosure issue.
Absolutely. So one of the common things, well, obviously, if you commingle billing, and I've had that happen before, clients commingle the bill, the government goes ahead and pays the billings commingled. But now you've got to straighten it out under the 2009 Act. You receive payment for work you didn't perform. You receive payment for something that work someone else did. I've had that happen literally last year. Guys, why can't this balance out? I go, that's not our work. It's government pay. You got to go back and tell them. You got to identify if you use the wrong rates. You now provided incorrect information in your proposals of what your qualifications are, as Pat said, you're billing for employees, what they're doing. Be mindful if you don't notify the government, the contracting office about overpayments. I've had this come up in the last year again with COVID. Well, everyone's working remote. Why don't you and I work it out? No. I got to tell the contracting officer that I received overpayments. That person can authorize a redistribution of money. We went through that with two government groups, and the contracting officer approved the reallocation of overpayments, the duplicate payments, but you have to do that. Make sure you get clear remittance direction. There are cases out there, and I was involved in one where the remittance direction was incorrect, was incomplete. People were applying it and it resulted in double billings. So be mindful, it's obligation under the 2009 Act. If you can't figure out what they're paying you, you have to go back and raise the question. I will give them their due. I think DFAS has improved a lot at my observations in the 2009 Act. I used to get the war claims that it just come with tens of millions of dollars. It's just a number. What are you paying and what aren't you paying? You know, everyone's happy to get the money, but then, hey, you got to tell me what you're paying so I don't bill it again. I sort of have a firm belief in payments and remittance, because I just come up with people that fall behind, should be reviewed within 7 days of receipt. The problem is it goes beyond another week, more payments come in. I believe you need to be careful of that. Make sure you provide the timely notice to the contracting officer. Only the contracting officer can authorize overpayments or reassignment of those payments and get it in writing. And when I just recently went through that, we went back to the government and said, okay, we identified duplicate payments. We asked you because you're behind the payments, and we reassign it, you reassign it, and we're confirming what we did. We sent them a little time chart back that showed exactly, and I had my client put in columns of how we had reassigned the money. So to speak, Helen Keller could figure it out. It was on the face of the document later on. Oh, I misunderstood what the client said. No, we put it in. We identified the columns and we put it in bold print per your direction, reassigning, and actually we even identified the invoice payment notes. Because it was a lot of money and I wanted to make sure later someone didn't say, who said you could do that? SBA certifications. Pat and I talked about this. This is something to really be careful of. DOJ is focused on this. Pat was saying, you know, what are your qualifications? I noticed a lot of cases come out of New Jersey where, well, I thought I was a small business. No, you weren't. I thought I was veteran owned. I thought I was woman owned. No, it was you. You didn't think. So you gotta be very careful. But I tell people, if you're dealing with these bids and you're bidding as a prime or sub, make sure you got the certifications from SBA. There were so many problems with veteran-owned certifications, they're not allowed now, but you want to make sure you've got certifications from SBA. Also,
And if you're a prime, you need to ask these subs to provide you the certifications too.
not accept.
Just DOJ updates on recent prosecutions, 2 prosecutions listed where the contract either gave some incentives or some advantage for using DVE companies as subcontractors. And in both cases, they were not qualified or they didn't exist. In one case, the contractor just used them. And they got popped with millions of dollars, and I'm sure they're going to be suspended or debarred also.
Yeah, I had one where we needed we needed a small business, we needed a woman-owned business, and it seemed to be this group was advertising in the Commerce Fair articles from Seattle, largest women-owned business in the maritime logistic field. I go, well, guys, let's do more than just reading an article. I said, I don't even see her name listed in the articles. So you go back and check on that. The other thing is, Pat alluded to, you gotta be very careful with affiliations, particularly when you're in the prime and you're teaming with a group. What's the affiliation or who you're aligning yourself? If I'm a large business and Charlie's gonna bid the job as a prime, he's a small business, I wanna make sure he's a small business. You know, is he controlled by someone else? What are the control points? You know, management, finance, facilities, equipment, personnel. What are these affiliation rules? You gotta be very careful because the affiliation rules can get you, can validate you, but then unfortunately, as Pat already indicated, DOJ comes knocking at the door.
And it's the totality of the circumstances test. It's not one factor here, one factor there is get out of jail free element. They look at the entire factual circumstances to determine whether or not the disadvantaged person actually, the veteran of the disadvantaged person, actually manages and controls the company. It's easy to set up to have 51% share of the company in stock, but they don't stop looking at that. They drill down to find out what's actually going on.
The other thing you can do is, and I've had this recommended on particularly on the West Coast, is go to the major bases in San Diego and other places. If you need small business, get the small business advocates in the bases to recommend their qualified people. There's lots of time you don't, but you want to make sure you've got some basis for aligning with them or saying, you know, as Pat said, I'm bidding a job, I need to show 40% disabled, disadvantaged businesses. I want to make sure when I certify that, and God help me, if I win, I bill the first time, I want to make sure they meet the criteria. Because then you're going to fall right into the False Claims Act. We all know the Disputes Act, the 1978 Act is the way that we can bring government contract claims against the government. As Pat pointed out, over 100,000. Is it in good faith? Do you have accurate, complete supporting data? What about your cost data? Check the cost. You've got to make sure you're billing, you can support the incurred claim cost. Watch the certifications. every aspect of your certification can lead you into a False Claims Act. Don't write a narrative that's not true. Someone says, well, Jim, we did everything we could, we cross-checked all the finances, but the story is hocus pocus. You got the dates wrong, you did that's wrong. Yes, it happened, but you got a little carried away with the story. You got to be careful. That's a False Claims Act. Make sure everything is thoroughly reviewed, as Pat pointed out. And the government uses this threat of fraud going after you. Oh, we're going to refer this to DOJ. And make sure you can prove your cost and the burden, as Pat properly pointed out. Yes, I don't have to go in and drill down, but I got to look at what the sub submits, particularly if they're large dollars. What's going on? I was working with the sub. How could the sub have a $17 million sub claim? The bid was $3 million. You know, so you got to be careful. There may be a legitimate reason for it, but you got to make sure you can establish that. False Statement Act, as we used to call this, is the little sister of the False Claims Act. Now that she's grown up and graduated, you got to be aware of the False Statements Act. You've got the penalties, you've got fines. What's this false statement? Statements oral or written, signed or unsigned. It's false, material, knowledge. The government relied on it. And the big thing is the courts have said the government does not have to demonstrate a dollar loss to come after you for a false statement. So examples: false certification in small business, false statements in your bid or proposal, false statements in your independent price determinations, on your clarifications, employee qualifications. You want to be very careful what you certify. People get into trouble to certify. That I've seen a claim going after people. They certify they turned in all the OEM manuals and all the books and all the operational instructions, and they had. I tell people, why would you do that? Just tell them I didn't do it. It's $5,000 the credit. But you got to be very careful what you certify. You get in trouble rather than just saying we didn't do them. I turned them all in. You didn't turn them all in. If you turn in work progress certificates. If I've completed all, I've moved on to the next stage of the work. I have all the checkpoints on all that. If you don't certify. Just say the government didn't show up. I've documented they didn't show up. We're proceeding with the job, but don't certify that you have the checkpoints.
This statute's a great example of the cover-ups worse than the crimes.
Right.
Half the time, at least it's a lot easier to prove than the crime, the underlying crime.
Right.
It's a felony. And all they have to do is show somebody signed their name or submitted something and get that person in a room and say, based on what did you do that? And if they say, I don't have any basis or I was wrong, well, this can trigger the whole cascade of problems in many respects, False Claims Act, debarment, suspension. I mean, even though it doesn't have the civil monetary penalties like the False Claims Act, it can still be company ending ramifications.
Absolutely. I'm going to switch back to you for the antitrust price fixing.
This is another, there's been so far a lot of talk about, increased antitrust enforcement by the Biden administration. And, those kind of cases take time generally to work their way through. But there certainly is a greater emphasis on it. They have instituted a bid rigging, price rigging, fixing task force now, and that task force is resulting in some settlements. But it is it's an area it's not the most common in the government contracts area, although you do have issues of bid rigging. From time to time, price rigging, price fixing, not generally the biggest problem, but bid rigging insofar as companies agreeing to submit what are known as complementary bids. Let's go to the next slide, actually. So this is the one I see the most, complementary bidding on smaller jobs where the government needs 3 contracts, three proposals, 3 bids. And one competitor go, well, look, the government will actually tell you in some cases, I only have 2 bidders now. So, so can you actually help us find a 3rd bidder? And I've had this in the state court arena. And so one of the contractors, one of the potential bidders loops in somebody else and says, look, just submit a bid. Just submit it. It doesn't matter what it is, or cost or anything. You're not going to win it, but they need 3 bids. That arguably can be complimentary bidding, where someone is submitting a bid. They don't really, their price is high, their delivery terms are such, they're almost going to be disqualified from the face of their bid. But it's being done solely to make sure the government gets the required 3 bids. And in some cases, I had actually a state court case where the state entities were the ones coordinating. The states were saying, look, we want to buy from X, we need 3 bids. You know, give us the names, we're going to go get 3 bidders ourselves. And then the feds came in and said, oh, it doesn't matter, the state's involved either. That's complimentary bidding, and that's a violation of federal law. So you got to be very careful with any kind of coordination whatsoever. And even if it's not, you're not thinking it's anti-competitively designed. You can't be talking about any of this stuff with a potential competitor. Subcontractors, suppliers providing pricing, you've got to be very careful. You're not, and this gets into the anti-kickback statute, you're not coordinating, you're actually asking subcontractors, give their best bid, give their best price, not pumping one up to give higher and you're going to reduce it later. You got to be very careful because they're now drilling down, or they have this task force that says they're going to drill down in all aspects of this kind of price fixing bid rigging.
I think you just have to be careful, and kind of you and I have seen is sometimes what happens is you know, I'm bidding with 3 people and that's fine. And I don't have to give the same price, but I can't be telling Pat, I'm giving you the best price. And don't worry, I gave Daniel a price twice as yours. I can't start giving him that information. And people make that mistake and it gets out. I had a case come up that they try to say that it came out of a trade convention. People were, I think Pat and Jim were talking about bidding on future jobs. And what are you talking about? Of course we were. But we weren't price fixing, but then it starts that way. And then well, I'm standing, the person who lost brings it up.
And here is where, you know, these price fixing, bid rigging things, the cases are made these days through text messages and email. And the thing you have to instruct, particularly your sales, your business development people, your sales, and I actually had this in a case. This is talking about New Jersey, a New Jersey auto parts supplier. And the sales guys are, you know, they're out there trying to, you know, get business, and it's more of a hand-to-hand combat outlook. But this one guy sends an email saying, we have really cornered the market for brake pads in this 4-state area. Time to raise prices, boys. That was actually in a single email. It's like a single, hey, please prosecute us for bid rigging or price fixing. So in every case that we've had along these lines, I actually had one where the companies were selling products to the Federal Bureau of Investigation. There was going to be an FBI procurement. And you should see the emails. Hey, let's coordinate on this. Let's coordinate on this. And no one's going, you know, this is an FBI procurement. You know, so you just can't make the stuff up. But that's where they prove the cases. It's extraordinarily dumb email traffic and stuff that you never should put in writing. But you see it. You see it all the time, and it's amazing. But it's almost always the sales and marketing guys who are out there, and they kind of lose sight. Everything's a, you know, eat what you kill system. Oh, and just to give you an example of what, this was a very recent, I pointed this out because just to give you an idea, this was a recent prosecution of companies for rigging bids on the sale of surplus government property at an auction. The value of the property that they rigged the bids for was $67,000. So the task force went after that. It just shows you, you know, if the conduct is egregious, the dollar value is not going to make a difference. They're going to come after it. And I think that's why they did it, to set that
Just set
message.
an example. Yeah, absolutely. Yeah. Great.
We talked about this and this price fixing, bid rigging. The other thing is you gotta be real careful when you have, as in this industry, employees switching companies. So you have incumbent employees coming over potentially to work with another company that's going to bid on the project. And you're gonna get into a situation where potentially inside information from one company is being translated. The employee coming over may say, well, I'll prove my value. Look, I've got some insight into how the other company was developing its bid or proposal, that type of thing. You just have to shut that down. We have the revolving door restrictions and all those things, but the people higher ups have to hear about that and shut it down immediately. Remove that person from the procurement, do whatever you can to untaint the situation. And in some cases, we have gotten involved and had to tell the client, you're gonna have to withdraw from this procurement because there's no way to put the cat.
It's too commingled.
Yeah.
I see it technically,
Yeah,
which
you-
is now commingled.
Yeah, you can't put the toothpaste back in the tube. So, and that really involves when you're onboarding people coming from a competitor. You've got to be very careful to explain the situation, know what they know what contracts they worked on, and take all the Chinese wall precautions you need to prevent that. That can be a very expensive problem. We talked about the strike force, and the two bids. It's just an area like it is with SBA DVE. It's a hot area for the government, and they're telling us that they're going to go after even the smallest examples of bid rigging pricing.
Well, one of the things that drive this, and we put it in the thing, is not do I believe it? No. I mean, you got DoD spending and federal government spending. They claim they can reduce pricing by 20, the outlay by 20%. Now, I think Pat and I said that, did you mean 0.2% or?
Well, I don't think that would be true in
No,
government contracts.
But that's their justification. They get everyone excited and believes the federal government believes federal contractors charge too much. So you get that whole scenario. But you've got they're proud of their first 2 years, what they've gone after, looking at people, you know, as Pat's properly pointed out, smaller targets, but they're still going after you. But the big thing is that the complimentary bid. Be very careful about that.
And the reason that I think that's a problem area is because it kind of sneaks up, because sometimes the government contracting officer is almost encouraging the contractors to find somebody else to bid this thing so we can get this procurement going. You got to avoid that like the plague.
If nothing else to say, you're right, none of them are any good. Why don't you just negotiate with me? That's
Sole
safe-
sourcing.
Sole sourcing. It's safer to do that. At the end of the day. Okay.
Okay. Again, here, you know, you've got to, and this is what kicks in if you don't have, you know, price competition. Then you've got to go through the TINA requirements of submitting current, accurate, complete cost and pricing data. And you really need to do that at the end of the negotiations, not before the negotiations, not during negotiations, because timing is everything. So you negotiate it, then you provide the cost and pricing data that's verifiable, and you're going to be okay. You don't want to do it early. I mean, stuff's changing all the time.
Yeah, you can't keep straight. I mean, Pat and I have emphasized this over the years. I've had situations literally both in this neighborhood here and others around the country. Contracting officer told my client, well, that's fine. We're not going to negotiate. Well, good luck then. But well, I'm not. You don't understand. You need to sign the certificate and then we'll start talking. But that's not going to happen. And by the way, I'm not as smart as you, so I would tell them, show me where it says that in the FAR. Well, it doesn't, but I'm telling you that's fine. No, you sign it at the very end. I believe in signing it after you and I shake hands. We've agreed on the price and the schedule. Because you know what? I think Pat is exactly right. On complicated procurements, I did one in the billions of dollars. I mean, my God, you know, you needed a room this size to keep the pricing data. You can't keep straight what's being traded back and forth, changed. They're changing stuff. You're changing stuff. No, I want to get to the end. And your best and final, then I'm going to lay out all the pricing. We'll finalize on that and then I'll sign.
And that could not be more important advice given our current supply chain problems, because, you know, things are changing daily. The other thing to keep in mind, you got to give accurate information concerning subs and stuff. So you have to disclose affiliations. You have to make sure that that's not something that's hidden, that you're upfront and saying, okay, we're getting part of this from, or pricing from this. They're an affiliated organization. You got to make sure there's not double, depending on ownership there, you got to be, make sure there's not doubling up of profit margins on that, passing that along. So it's not just all pricing. You have to disclose some of the relationships as well.
And to Pat's point, make sure that you put that in writing. Because lots of times I've had it come up, and you're talking to the contracting officer, I say, well, Charlie, I need to tell you that Pat's an affiliate, but he forgets, not that he's a bad person, he's put it in writing. And I recommend putting it in writing when you first submit your proposal. So it's upfront, and when I can go, well, I told you that, and exactly what it is and what they do, and what their price is.
And believe me, when the DCIS pays a visit 4 years from now to that person and says, did they tell you that this company was affiliated with them? I don't have any recollection of them saying that
I
at
don't
all.
remember that at all.
Yeah.
In fact, I don't know who they are.
Yeah.
They never told me at all.
Okay, so,
Procurement integrity, the same rules, you gotta be careful, you're not getting unfair competition.
and we talked about that again, where I see that pop up the most frequently is where people are leaving one company, going to another company, or leaving the government and coming into the industry. That's where someone's bringing information with them. They're thinking, well, I'm going to an organization, I want to prove that I'm, a good hire, I'm doing this. They're not thinking I'm violating the law, but you have to be very careful. And that's why, when you onboard people, you got to be very careful on this, particularly with this statute and its requirements. This is, if not the same as the Swiss Army knife for the False Claims Act, the anti-kickback statute. When I first started practicing, there were very, very, very few instances of the government using this statute. But I think over time they realized that it's very handy because it can reach down through the subcontractor chain or up through the subcontractor, through the contracting chain. And they can turn what otherwise would be normal and ordinary behavior in the private sector, taking people out for golfing, letting them use a vacation house, those types of things that in the private sector, perfectly lawful, no problem. But those kind of, more than one, a pattern of practice where in order to get work or to give work, you're giving things of benefit down to the decision makers in your supply chain. I mean, very careful with that because they have turned that into a pattern of practice of giving kickbacks in order to get work or keep work. These are pretty simple, usually the bribery statute particularly. And I'm giving you a bag of cash in order to get X. And you laugh, but I've actually had cases with brown paper bags of cash delivered at a Denny's to a government official. And of course, the FBI has these long range photographs of the whole thing. And it happens all the time. Or there's somebody's recording it. I had a case where our firm name actually came up because these two entities were fixing rig prices for contracts and giving bribes to the government. And the FBI recording was, hey, are you represented by a lawyer? Yeah, I got a lawyer. He told me not to even talk to you. Who's your lawyer? Kaufman and Knowles. He goes, oh, I got a lawyer too. He told me not to talk to you. Okay, what do we want to do about paving this month? Paving contract. Well, that's easy. And so everybody understands bribery. Gratuities, a little bit different. As Jim said, a lot of companies are going to just a flat, bright line. We're not taking you out to lunch. We're not taking you to a concert or a NASCAR or sporting event. We're just not doing that, as it's just too hard to police. There's too many nuances. We're not doing it. It's hard because, people, I don't think government employees necessarily have gotten used to it, but that's a hard rule sometimes, but it's an easy rule. We recommend it. I think everything's moving in that direction anyway. So, but a gratuity does not require a quid pro quo. It just requires, I'm giving something of value because of our business relationship. And invariably, that person, when it hits the fan, they come in and say, look, we're friends. I went to his daughter's wedding. He came to my daughter's wedding. We're friends. This is a friendship relationship. Okay. Well, when you went out to dinner, did you turn your receipts in to get reimbursed by the company? Yeah. Okay. Your whole friendship thing is gone. That's a business thing. And the courts have said, look, if it's 1% related to the business relationship and 99% related to the friendship relationship, that satisfies the business relationship, that will constitute gratuity. So you're just better off not going down that road. The forfeiture statute, very powerful. It really reverses the presumption of innocence in many ways, because the government really, once they have an allegation of fraud or criminal conduct, they will seize the property. They'll seize the assets. And then it is up to you to come in and prove the asset or whatever that's been seized is not the fruits of any criminal wrongdoing or fraudulent activity. So it clearly reverses the normal ordinary presumptions, and it gives the government a huge bargaining weapon to use, because they're essentially sitting on your assets. They freeze your bank account, they grab your cars, they grab your house, and then they say, come and get it. Come to court and prove it different. So it's a very powerful tool. Mail and wire fraud, all that does is, if any communication travels in interstate commerce and that communication is part of some scheme to defraud or anything else, it violates the mail and wire fraud statute. So that's just really a jurisdictional hook that the government can use to criminalize what otherwise might be within a state or would have no other connection to a federal jurisdiction.
I want to think about who we this suspension and debarment. Pat alluded to that before. Obviously, if you had a false claim or improper action, the government can move to suspend and debar you. Usually the debarment is 3 years, not less than 5. Basically, since 2000, the 2009 Act, they threatened violations of the 2009 Act to go after suspension and debarment. One of the most important things that I think, Pat, you and I can agree on, when I've had the friendly government investigators or DOJ come to the door, is, does your company, does your client have a code of conduct? Does it have regular training, whatever else? And okay, you want to be able to say yes, yes, and yes, and then let's talk about what happened in this instance. If you don't have compliance training, if you don't do it at all, or the management never attends, they're going to say, well, no wonder the problem happened. So you want to make sure that you can demonstrate right off the bat. I've even had questionnaires that the investigators asked to provide copies.
Well, if you look up the grounds for suspension and debarment, the number one thing they want you to answer is, do you have a compliance program, an effective compliance program? That's the first element of it.
So what I strongly recommend is what Pat and I talked about in the past is, if you get a false claims action against you, you're looking at suspension and debarment, you're eventually, DOJ is going to take its pound of flesh out of you. And then you'll get a referral to your agency or command suspension debarment office. I believe, and I think Pat, you and I agree to this, you want to become proactive. I don't believe in sitting around, let me wait for the nasty letter to come. I believe to try to go down and meet with them. I've successfully over the years go down to the main suspension debarment office for the Navy. The Navy is under the General Counsel's office. Go down and meet with them. Hey, what's going on? What are the things you want to be thinking about? You want to demonstrate that regardless of the sin in the past, that your company today is a viable, responsible government contractor, and there's no cause for suspension or debarment. And the way you first establish that is under the FAR, what's called the evaluation factors. And what you immediately do is you work with your lawyers and present a good story of what happened, confess the problem, what you're doing to avoid the problem in the future, the controls you have, and answer the questions. If you become proactive, the suspension debarment office, you're much better off. And then what you do while they're reviewing is you demonstrate ongoing training, corrective procedures. I like talking with them because, even if they say, well, I can't say this, but oftentimes I picked up, there's an issue they're concerned with, you deal with that issue. So the next letter you file with them, and I'm sure Pat, you do the same, you constantly filing updates, report to them, you've done the training, you've done this update. Hey, you were concerned about this is no longer with this company.
And you have to actually go into those meetings with your own mitigation plan.
Right.
You can't just show them, and say, what do you guys want? They go, that's not what we do.
That's not how
Show
it
us what
works.
your
Yeah.
plan is and we'll comment on it.
Yeah, I mean, I've literally had one, that they basically adopted our whole file. And they asked me to send all the training stuff, they put it all in, but you want to demonstrate you're proactive. 889 requirements. Okay, we all know that it came out. You gotta be careful who you're buying from, certain selected companies, the Chinese companies. You've got the 889 A1 rules. The government doesn't buy. And number two, the B rules that you're not entering in a contract with a company that uses that equipment. So one, you're not selling it. Number two, you're not using it. You have a certification, but remember that certification and what you want to do to protect yourself, that certification is applying to you as your position as the contractor or a subcontractor. You're not representing who flows now. We got involved in this certification. It applies to prime, not the subs. DOD and the transportation world, both related to the war in Iraq and Afghanistan, whatever. We pointed out to them, well, it's great the stuff you want us to do, but Pat wants me delivering all this equipment through Singapore. I have no idea what the Port of Singapore uses. And moreover, you want me to disclose all this information. So again, and we said we can certify what we did. So I'm sure you guys, we put cover letters in our interpretation of what we're doing. We're doing reviews, and you constantly, if they want a yearly update, some commands do. You say it's an ongoing review. If the issue comes up, we'll let you know. But you always want to make sure I take the position, it only applies to me. I don't know what the sub is doing. Obviously, he's got in the window and he shows up at my facility with banned equipment. I'm going to tell him to get it off the property.
Right, but you should be flowing this down, even though you can't police it.
Right, exactly. Yeah. So you flow it down, but you're not liable. We've also kind of alluded to the revolving door. Interesting, I've seen some changes. I don't know if you've seen it happen. I've seen in the last 2 years on the DOD side, certain commands taking a position and becoming very strong on instructions to employees that want to leave and saying, you've got lifetime bans on certain information that you've worked on personally substantially. You've got a permanent ban on disclosures, not public information. I'm very sensitive when people come to me, in fact, you probably agree, hey, Jim, we'd like to hire this guy. What's going on? Well, there's a procurement in the street and he worked on it. I said, no. Let's wait. That is not a good scenario. That's going to run afoul, as Pat alluded to, all the problems. Then I've had an employee come and say, okay, Jim, we waited now. He says he's leaving. Let's hire him. No, I want to get a letter. Get a letter from his employer that he's free to leave and what his restrictions are, because then it's spelled out, a written legal opinion.
That's key. You got to get and plus it just saves your company a lot more
Right.
money. You don't hire outside lawyers to give an opinion that the Navy could just disregard anyway.
Right.
And Jim's right on, on this issue about making sure that this person you're bringing in is not going to destroy the procurement that you're bringing in, that you would want to bring. And even if you could cleanse them of whatever problem they would have here, you should expect a bid protest. Let's say you win, you should expect a bid protest from the competitors once they learn this person was hired anyway. And then the test is going to be, is there a conflict or the appearance of a conflict? And that's a very difficult standard. So, it may be more negative than positive, and often will be more negative than positive, bringing in somebody who's from a high level, who may have, contract integrity issues that are going to taint whatever victory you would otherwise get.
I saw recently, over the years, when we were doing the course, we talked, I saw an award of $378 million, probably not about 5 years ago, it was overturned because of protests of conflicts. I saw one this year was over 600 million. And the whole problem, they'd hired people, they had conflicts. And I'm not putting up my hand until after war. If Pat wins, when I put up my hand. I said, well, of course he won.
Right.
He brought those two guys in.
Right, and again, the test is gonna be, was there a conflict or was the appearance of a conflict of
Right.
interest? And if that's not all vetted with the contracting officer before procurement, you can guarantee the contracting officer is gonna be of no help to you afterwards when they learn that this has become an issue and you didn't vet with them up
Oh,
front.
yeah, now you've got them.
Because
hanging.
now they could, and the GAO has said, look, if you had brought this up earlier and had provided a conflict mitigation strategy that the contracting officer had approved on, we, the GAO, will not second guess that. We won't, but we sure as heck will second guess it if the contracting officer wasn't told about it and allowed to say grace or not grace over it from the outset.
And which segues right into the organizational conflicts, as Pat alluded to earlier. Be mindful of one of the restrictions. You don't want to have anything that influences the judgment, but gives you an unfair competitive advantage. Did you gain business information? Did you gain business information about other people from someone you hired? And as Pat has said, when it comes up, you want to go right in and disclose to the contracting officer, hey, an issue's arisen. I want to tell you all I can tell you. What's your position? And you be mindful of things you can and cannot do. But once you've gone down the path, sometimes it's irreparable harm. But you want to be very careful to avoid conflicts of interest, because GEO is looking at, and I think GEO has taken that as a legitimate protest issue of years ago, me just complaining that I lost the path to you. But now they're saying, well, hey, wait a minute, there's some merit to that. I see what you're saying. There was an engine, or I saw one where the company was unfortunate. They hired a group, a subcontractor. The sub did not build sufficient Chinese walls. One of the groups in his subcontractor had worked in the procurement. They weren't involved, but they could not demonstrate. They hadn't made commingling of information. And GM goes, well, what's that mean? An open sieve going back and forth. He was working on the project. You're telling me he didn't tell you, but you didn't tell the contracting officer.
Yeah, you're gonna lose that
Yeah,
argument.
you're gonna lose. Personal conflicts of interest. You want to be careful of employees when they come up their rules to go back in the FAR. You've got to be mindful of how you're doing stuff. And what you want to make sure is in personal conflicts, if there's a problem, you've got to disclose that to the contracting officer. Covered employees are not with the COVID issue, but going to the point is a person is involved with the company in procurements, pricing, whatever else, and he's running a scam on himself. He's also bidding, he's getting bid information, bidding to all the suppliers. You want to be careful. That's a personal conflict of interest. And you have to maintain that and notice to the contracting officer. Some guiding rules I've had it come up with people saying, well, we got to have guys have outside employment. Well, I'm not begrudging anyone outside employment, but make sure he's not involved in employment that conflicts with the employer. Is he gaining information? Does he have a side business that is not selling to the employer, but selling to a sub?
You gotta be careful there about affiliations sometimes too, because if your employee, she doesn't own the company, but her husband owns the company that's selling to you or to a sub, that could be a problem.
Yeah, you have to, you're seeing the right, someone says it's all right, well, what's it? Well, it's my wife. Well, I mean, you two live together, you have the same business. I mean, she doesn't, no offense, she's a nice woman, she doesn't know anything about the business. You're clearly giving her information, now you're gonna have a problem. Number audits, okay, audits didn't come in, I bring this up, obviously we all know this, we've talked about this. If there's an audit, you've got to cooperate, answer the questions truthfully. If you don't know the answer, I bring this up on certain contracts I've seen dropped in on FMS contracts and others in the last few years, giving almost carte blanche open books that the auditors can come in and DCA comes in, and I had one in the last 2 years where, well, no, we think the audit is start from the bid. No, it's a performance audit. Well, how do we, literally the first question, well, how do we know that your client didn't get paid more money? Well, where would I get the money? The federal government's paying me, but you want to be careful. But my client had agreed to an open audit. So want to be careful. If you're looking at it, there are audit rights in the FAR, but this was in a clause is entered. So be mindful of that. If you have an audit, you have to cooperate, but be careful if you're signing contracts, particularly for a military sale and on contracts where DFAS is paying you directly and DSCA is the administrator, they're putting in their own audit clauses. And they're putting in audit attachments And I don't know if you've ever seen those, it's a certificate thing where you gives them rights to look at stuff. It's fine, but the problem is it becomes impossible to prove stuff. You know, well, how do we know this didn't occur? Well, how do we know? No, the price was fair and reasonable determination. We want to go back to the price. Well, as you know, pricing reviews are required prior to award, not after.
Yeah, and if you bid, I've seen it too, where you bid a firm fixed price contract, you get an award, and they want to audit your costs.
Right.
We shouldn't be able to do that.
No, I got fixed rates. I literally had the government say, we want to go over the rates. I said, guys, my rates were determined by you and you have a fair reasonable determination. The other rates are contract rates we both agreed to. We're not auditing anything. Nothing. I want my money. So you have to be mindful where you are and don't fall for that. Performance audit confirming, did you do all the work? I build 100 homes. I built for 100 homes. That's fair. But not, I want to go back and see your cost. So, okay, and we're gonna move on to the final part for Pat.
All right, well, don't traffic in persons, okay?
That goes without
We'll cover
saying.
that.
We moved out of Afghanistan. There's no
That's
excuse.
really for you. Pete. Okay, next, oh, and no conflict diamonds for traffic, for trading either, okay? OFAC, okay, now these are just trade. I don't know how many companies are involved in international trade, but there's a lot of requirements here. You cannot, obviously, it's going to be mostly common sense. You can't, there's embargoes of certain countries like Cuba, North Korea, Syria, and Iran. You can't deal with them either directly or indirectly. One of the things that does come up in the government contracting area sometimes is, and I've seen it in the last couple of years, is there'll be contracts with Saudi Arabia, UAE, Qatar, and for supplies, provisioning, services, and those countries in the part of the Arab League, those countries will often have a provision in all their standard contracts that say when you sign the contract, you're agreeing to provision that says you cannot sell anything to Israel. They have an embargo of Israel. And if you agree to that provision, that then violates US law that says no contractor can sign an agreement that prevents them from selling to Israel. So you've got this three-dimensional embargo thing going on. So just if you're dealing with any foreign government contracts, make sure you go through it line by line. And if you see that kind of a provision in there, you have to get it out of there. Signing the agreement is itself a violation of US law.
Also, if I could, in the document, it obviously with the America over there for 20 years, during freedom and Iraqi freedom, you have a lot of growth of in-country industries. So, I have disputes with DOD. We moved probably with Saudi Arabia and screaming later. Wait a minute, what's going on here? We have this in our country. Let's say, well, we had one. I said, well, no, it appears to be lumber, but it's more than just appearing to be lumber. It's pressure treated, whatever. But you want to make sure when you're signing these agreements, what they're doing and what the U.S. government is saying, what the basis is of you moving or supplying their stuff or the U.S. government in their country.
And you have to do a little due diligence because I had a case where the buyers of these wood products were from Canada, but any kind of background, even a Google research revealed that they were really, their main buyers were in Syria. And so, my client had been selling these products thinking they were selling them to a Canadian company, but had done no due diligence, which would have uncovered, which the government quickly did, those products were being sold into Syria. So they had a huge problem of violating the embargo and sanctions and all sorts of things. So you can't just take it on faith that whoever's buying from you is not rather obviously selling into an area they can't be selling into. ITAR, which is next, that's pretty simple. Usually they pare down the list, the munitions list. It used to be have all sorts of stuff that really wasn't technically munitions. But one thing to remember when you're selling any kind of products is the software, the owner's manuals, the how to do something. All of that is also considered part of the object. So it's going to be considered a weapon or at least on the munitions list. So it's not simply hardware. It is also all the know-how that goes with that. That's also going to be covered and is going to have to require an export license through the State Department to sell outside the US. This is even more nuanced, the export administration regs, because these are dual use items. So you can have example that's come up is infrared night vision stuff. Well, that can have a civilian, that can have a military use. So those types of things are going to be covered and require a license under these regulations maintained by the State Department also and the Commerce Department. So you're going to need a license to export it. You're going to have to tell the Bureau what area of the regulations apply. And like encryption is a big thing now. So if you're in the business of selling encryption software, that's an item that has dual use. That's a perfectly proper civilian use, but it can't have military. Surveillance equipment. And if you're selling surveillance equipment to any kind of Chinese company, now you got to research, well, does that Chinese company have any connections to the Chinese military? Does it have any public or common ownership? Does the state own any part of the business? Sometimes that's hard to figure out. So if you're selling into those areas with those kind of dual use products, got to be very careful to do some digging to find out who's the end product, what's it's going to be used for, those types of things, or otherwise you're not going to get a license. And okay, the Foreign Corrupt Practices Act, and if you go back to Jim's initial bullets, this is a huge growth area for the government, a huge growth area. And it prohibits any kind of bribes, payments, called grease payments, these kind of things. If you want to sell into Mexico, if you want to sell into a lot of Latin American countries, the Eastern Bloc countries, there's a lot of countries out there that have this either a reputation or a demonstrable history of having to do these kind of things in order to do business in that country. And so a lot of US companies, a lot of international companies have been popped with huge number of penalties and fines for violating the Foreign Corrupt Practices Act. The other thing to remember is, so you got 2.78 billion in recoveries in 2020 under the Foreign Corrupt. That does not even count what are now common piggyback cases by the country. So in Mexico's, for example, Mexico has figured out that they passed a similar Foreign Corrupt Practices Act statute. So once the DOJ investigates the problem, figures out how much bribe was used, what kind of the contract, the value of the contracts, and they settle with you, then Mexico rings your doorbell and says, oh, by the way, we want to settle with you too now. And that's not just Mexico, Egypt, all sorts of other countries around the world are piggybacking on US Foreign Corrupt Practices Act prosecutions and getting their cut after this 2.78 billion in recoveries by the DOJ has been. So it's very expensive. It's become a money-making operation for a lot of countries around the world. All right, so this is just kind of the wrap up. We've talked about it a million times, and that is things that are common, ordinary, perfectly lawful business practices in the private sector are can be felonies when you're dealing with the federal government and public monies. It's not just government contracts, it's federally funded programs, grants, those types of things. Got to be very careful when the public money is involved. Only the contracting officer can bind, obligate. You all know this stuff, but it's extraordinary how often it still comes up. You say, well, the guys in the deck place, they told me, go ahead and do it. They take care of us. Well, you're never going to find that person when it hits the fan. The person's not going to recall. And even if they said, yes, that's what I told them, your contract and the regs say only the contracting officer can obligate the government anyway. So it's of no use. Best efforts by the contractor in performance or billing are not a defense. You got to get it right. if you knew or should have known what you were doing was not right, not passing muster, you open yourself up to False Claims Act liability. Ignorance of the law is no defense. Okay, this is just that gets back to the willful blindness, deliberate ignorance standard. It's just not going to work. Ask before you act. Again, get the contact with the contracting officer up front, get their approval, get their authorization, or get them to say no. You're going to save a lot of money in the long term. And then, we can't harp on this enough. The robust and comprehensive compliance plan is an actual necessity nowadays. You have to have it, even if you don't satisfy the technical requirements of the regulation for when you need it. You really absolutely have to. And what Jim said is very important, and that is don't create a Encyclopedia Britannica compliance program. I actually had a jury trial where it was a lawn service company, and they had a compliance plan that somebody had asked somebody else, hey, find a compliance plan on the internet and then do a word search and get rid of, as it turned out, Raytheon and put John's Lawn Service in, right? So we go to court, we got a compliance plan, looks like, it's for Raytheon. They're supposed to have quarterly meetings in Denver. They didn't get rid of that. There's quarterly meetings in Denver. And so the prosecutor who recently retired, a friend of mine, he was lovely because he had the president on the stand for like almost a full day saying, well, let's turn to page 200 of your compliance plan. Did you do any of that? No. So the worst thing you do is create a compliance plan that you had no ability or intention to comply with, because all you've done is create a big stick for which the government lawyer can beat you to death with. So make it something that's concise and doable, because you're going to actually enforce it, and it's going to be seen as something that was a living document as opposed to something you created and stuck in a drawer.
And that's the route.
Yeah.
Open up for questions.
Absolutely. We know we're standing between you and the
Yeah.
bar.
The question is the bar open?
We did have 2 questions from the chat. Some were from earlier, but I know you touched upon it. We had a question about, for instance, when it comes to the COVID mandate, and I know a lot of regulations haven't been voiced yet, but how does the December 8th mandate affect delivery drivers?
Well, that's the point. So it's a valid point. I think Pat and I have a publication from one major contract in this area that they're going to let drivers on. They're going to require masks. I don't know if I can't tell you if they're going to ask them to fill out a form. My understanding is they're going to allow them to come on masked and say, okay, you're going to Pier 6.
Mhm.
That's where I want you to go. Don't go to the dining hall.
Yeah, that's what I remember you saying. Yeah.
So that, on the military bases, that was the question we raised 2 days ago. They asked for a timeout for 2 weeks. They need to get clearance because they couldn't get DOD instruction. We asked it for 2 reasons: for the clients going on the base and delivery.
Mhm.
On a given base, you could have 1,000 containers, big base coming on a week. So, how do you get on? But that's my understanding is right now that the 10 is that as long as they maintain security, that the drivers, delivery people will be able to come on. I can tell you, the difference of, and not faulting Norfolk, but after the 9/11 and the different things, I'm sure Patty had the same experience. I'm sitting at the gate there to get on the base, and they, doing a strip search, searching my car. Meanwhile, the pizza van just drives in, the guy waves, and no check at all. But that's my understanding. They're going to try to figure out a way to get the companies in.
Yeah.
The delivery companies in. The reason it has to be flexible because in many areas of the country, 95% plus are independent truckers.
But then I heard a story from an attorney at Joint Forces Command, and they apparently have third-party out gate control. And that company was just stopping everyone and saying, have a card or you don't get in. And so there's a miscommunication.
That will work until the base can't feed it.
Right.
Another question was, what is the process to obtain formal certification from the SBA for being, as an example, a service-disabled veteran-owned small business?
Okay, if you're that business, you need to go to SBA, present your criteria credentials, so to speak, to them. Let them review it and give the certification. If you're a prime, then you want the subcontractor to present that.
And I think they've consolidated, because you used to have two different veteran-owned business certifications, one by the Veterans Administration.
Which is DOJ doesn't view that one.
And then the SBA, and so I guess Veterans Owned was a self-certification.
Right.
They've merged that now.
Yeah,
So
there was a contracts committee not too long ago that I believe we covered that. I can't remember who's the presenter.
You can't, there's no self-certifications
Mhm.
on the small business owned or whatever, but everything comes from SBA. But the recommendation I've always seen is get the certificates, because not that you don't know the people, but I don't know their classification. And I want to make sure if I'm aligning with them on a 40% requirement, or aligning with them as they're the prime bidder, that we're not going to get thrown out later. Challenge.
And that's all I have from chat. Appreciate
Okay.
everyone. There's,
Guys, I think,
Yeah.
you guys do a great job here. Pat and I just tried every year, just bring you some of the updates. COVID and cybersecurity are still out there. We'll see what happens the next few weeks. What I always say is, at the end of the day, we used to have the problem in Afghanistan when we backed up, and we had massive backups to the gates, and how this clearance stuff. Well, that's good and grand, but I got 1,000 trucks now outside the gates. At some point, I got to get in. So at some point, you're going to have to determine what is the access to workers. And if you deny everyone access, there's the sort of projection of 20% workforce could be lost, which then is going to result in significant schedule and cost impacts in claims.
yeah, and they're going to have to give some good guidance on, okay, what's a medical, what's a medical exemption, what's a religious exemption. And so the medical might be pretty easy. You got a note from your doctor. The other may be more difficult to, figure out.
Yeah, and just how it applies, and then, then the question, that's exactly right. Where does it come to the guy who's doing the production work, or is the guy that remains in an office and never goes to the true work site? Yes, he's a covered contractor, he's a covered employee, but he doesn't go to the work site. But unfortunately, just not had the guidance here.
A lot of people take the term religious overnight.
Well, that's already been the case. There's been a lot of recent conversions lately. So, and those are going to be harder to figure out.
But again, so the lead on the health and safety stuff is religion has sometimes not helped when there's a health and safety issue of the community, or safety in the community.
Yeah, like medical professionals.
Yeah,
And I don't think it's going to help much with police and rescue either.
I think the real question comes down to, and religion is a squishy sign of what's legitimate, how is it reviewed? What's some states view it, give a greater leeway, others don't. And you'll see a lot of cases with an article in the Washington papers on the weekend, professor out at the University of California, Berkeley, the law school, and giving thoughts. But what is a true religious exemption? Unless it's not just saying that, I object to you playing loud music, but now we have a health safety issue with the COVID, and that's sort of a mix that's everyone's saying out there. But I think you'll have to grant some exemptions in the medical side because of the ADA issues out there. So they'll require some guidance. But yeah, I think if you're just my religion is to worship the Budweiser can, I don't know if that's going to qualify. I mean, you may put it down, but I don't know how far that's going to go.
Culture.
Yeah. And I think I read somewhere where every major recognized or traditional religion has already come out in favor of the vaccine. So it's
Right.
you're going to have to come up with almost your own religion.
Yeah, I think that the people that have the medical, the two that approach me or sounded, I said those are valid medical. I'm not an HR lawyer, but those are valid medical, and present that, write it up. The forms are out there, you present it. I think where the issues coming up, that is what is going to happen when I view that as a true valid medical exemption. And it's written up by a doctor, and I've got it. Now I go to work, though, not at my site, but on a government site. I just normally able to ship them. Or I go to defense contractor that's perhaps not in our marine world, but my guy's gonna do it well. You know, he says no access if you don't have a vaccine. That's where the issue is gonna come up, and I think that's where DOD, we always say DOD, but DOD is the bigger money, and you gotta figure that out.
But someone asked, and it was a great question about the labor force. What's the impact if you start losing a lot of key skilled labor or anyone else? Are you going to get some consideration from the government? You know, in terms of extensions of time and maybe some additional money. I'm not seeing a great warm and fuzzy on that yet, but certainly you need to, as Jim was saying earlier, got to at least reserve some language in there to keep that claim potentially alive.
Yeah, how do you get there? The one interesting thing is, it's not that I'm jumping from company B to company C, because company C can't afford me either. I'm not vaccinated.
Yeah.
So, but we'll try to keep you posted on that as it develops. But thank you again.
Thanks.
Thanks everyone out in Zoom land.
Thanks, Jim. Thanks, Pat. Yeah, that was great.
Sure.